context of marriage. The case of the relatively lawsuit is that the sister of this petitioner, she was married in the village where the project lies, and since 2018, they picked up relation, they picked up friendship, and they fell in love. That is mentioned in the contract.
Yes, Your Lordship. Your Lordship, 2018 yes, Your Lordship, 2018 to 2023, the petitioner and the victim was known to each other, and on the pretext of marriage, Your Lordship, that I'll marry you, relationship was developed, Your Lordship. केस डायरी में Your Lordship आया है, स्टेटमेंट भी आया है, the victim का भी, उनकी mother का भी, and finally this FIR complaint was lodged when the mother of the petitioner came to the house of the victim stating कि शादी नहीं करवानी. So we at the stage of being yes, this case and much more as being is concerned, you have a consensus please. आपको नहीं पता है तो हम आपको जेल ऐसे नहीं देंगे. आपको पता होना चाहिए ना चार्जशीट हुआ है पता चलिए पास होगा करके.
Item 2, DT.30.07.2026.
I'm from Patna, Bihar. I have to mention a case here. And this one, I'm sorry for that. It's a salary matter for ACP and MACP. Increment matter. It's very urgent. This case is from 14 months. It's a fresh file? No, it's not fresh file. It's a salary matter. ACP, MACP increment is not granted to the petitioner.
When did you file the case?
In 2024.
There was no earlier since then.
Suddenly, pension is very low, and the petitioner is suffering from heart problem.
Who's for this?
Yes,
Who are you? Are you there? No, I'm afraid. Which is your husband's?
yes.
And you have his daughter?
6 years.
Auto system. Item 2.
This means FIR lodged in Ms. Mishri under section 69 of BNS for having sexual relationship on the pretext of making false promise of marriage. That is first one. And second allegation, ma'am, for causing miscarriage or abortion of the victim without her consent. There are 2 allegations against me.
This was statement and decision 123 reveals that they love each other and from the last 4 years they are having a relationship.
For the last 8 years, then she was 14 years of age.
But charging has been submitted at the box. No? So many was basically for 14 years of time. So the charging
But para 54 of the case है, the independent witness.
वर्षों से ट्रेन प्रसन्न चल यही तो बोला
वालिदा अभी पिता काम करते हैं और आना जाना लगा रहता है. अभी की प्रकृति पर संबंध कुछ में बताया गया कि उस संबंध में जानकारी लिए दोनों के बीच काफी दिनों से संबंध चल रहा था और इस संबंध में गांव में कई सामाजिक बैठक भी हुआ था. लड़का पक्ष टाल मटोल कर रहा था, शादी करने से मना कर रहा था और इसके लिए वो हमेशा टाल मटोल कर रहे थे. the council secretary matters, the council for the service. As per the allegation, it said the petitioner and the victim were having a consensual relationship, and she had love affair with the petitioner. To some extent, the charge sheet has been submitted. Charge sheet has been submitted under section 69.
69.
69 of BNS. The learning council for the employment by using a prayer is something that there was love affair for years together, and at the initial point of time, the victim was married. And the victim also became pregnant, and without her consent, she was subjected to abortion. While the charge sheet has not been submitted on section 18, the accountability up to the level council for the state, they have submitted that charge sheet has not been submitted on section 89 of this, nor charge sheet has been submitted under the provisions of box 42. A court of sorry, not court of friend. Council for the state, after the council for the parties, and considering the statement of the victim recorded on section 183 basis, there appears to be love relationship between the petitioner and the victim for quite some time. The charge sheet having been submitted, the petition
Under section 376 of Constitution.
for the learning council secretary is the learning council for the petitions is custody since 5/5/2026, and charge sheet has been submitted on 27/5/2026 for alleged defense on section 376/506 of IPC. The learning council submits that as per the allegation in the FIR itself, the petitioner and victim were known to each other since 2018, and the petitioner used to help the victim from time to time as it was required. However, it is alleged that the petitioner established physical relationship with the victim in the first time and ultimately refused to marry. The learning council submits that the first incident that the incident as mentioned in the complaint petition is related to the period 2018 to 2023. And the complaint was lodged on the 11 The learning council submits that there is an element of consensus among the parties. The learning council the victim and the state have a two separation made, and that submitted that there is direct allegation against the petition. After taking the learning council to the parties and considering the fact that the petitioner and the victim were known to each other since 2018, as mentioned in the complaint itself, and charge sheet having already been submitted, the petition is objectively
Item 3, DA 5728 of 2026.
Because under section 72 of Venus and 4 6 of option and charges under 351 subsection 3.27 subsection 3 of Venus and 4 6 of option. Please, this will not directly named in FIR. One of the co-accused
Not named. He was named Sanjay Rao.
Sanjay.
Sanjay Rao. नाम क्या है? Fail and assistant. Sanjay Rao. FIR
FIR में देखिए
बहुत ज्यादा केस हो गया.
But I will here on the basis of not on the basis of statement of
It's a case of
Gang rape.
gang rape. You are named in the FIR and trial is going on. 3 out of 11 cases are released. I can expedite your file, but you are named accused.
but his name came after conditional statement of
This is not correct. It is there.
let's see deposition also she was not going to
Deposition अभी नहीं हम आपको appreciate. कोई भी उसका bail already rejected. There is not been made. Right from the benefit of it is argued that the petition has been made in the FIR itself. The present case is a case of damage. The review order itself also reveals that victim in course of trial has identified the petitioner and other accused. The legal counsel for this case is also after hearing the counsel of the parties, constituting the influence and leadership. And the application accused have been rejected by Warwick Bench in the 1/9/95 of 2026 by Warwick Bench of March 2026. This court is not and upon going through the statement of the victim decision by the 2026. This court is not inclined to the last of the petition by the victim. The victim or the integrity of the witnesses release and out of 13 charged witnesses, 3 witnesses have already been examined. Last year, 21 2026. The first state is directed to the remaining witnesses are produced before the court. The counsel for the state is directed to communicate this forward to the director of the school and also to the escalator and the district court.
Your Worship, I appear before informed by appearance of the court.
Counsel for the informant is present. आप फाइल ठीक से करेंगे Actually,
आप कुछ बोले हैं किसी और के बेसिस पर, लेकिन आपने फाइल से नहीं। वैसे भी नहीं victim examine हुई है, वो बोल रही है कि हमको बाद में बताया कि इसका नाम है। आपको जो इंस्ट्रक्शन होगा वो victim के स्टेटमेंट का FIR ध्यान से पढ़ा करिए, ठीक है? ऐसा नहीं हो कि कोर्ट आपसे ज्यादा पढ़ के चला देने लायक होगा तो वैसे ही लेकिन ट्रायल आप कैसे
From date is followed with effect item 1, APA file number 1171/2026.
we should there's this one highly for ignoring of defect. The leadership, there's this one defect which was pointed out that the enclosures along with the FIR were not filed. The leadership, the enclosures were not supplied, even with the certified copy. And there is a certificate just after the FIR in my IE. I have another certified copy of the FIR at the last page.
you produce the FIR sorry.
I don't have any objection regarding.
I need number 8689/6. The level council for the teachers and staff. This integrity application has been filed for noting the defect in as much as the enclosure A to C to the FIR has not been annexed along with it. Such that in spite of applying for certified copy, those enclosures are not included. Considering the reported sanctions, the defect regarding filing of enclosures to the FIR is ignored for the present. There can be no doubt that in the case diary, the enclosures must be present. Was this case on next first?
Orders item 2, PA 6016/2026.
For the informant.
आपके पेरेंट्स भेज दिया साइन कर Item 3, BA 6100/2026.
STP more than 2 years. Litigation हो कि 31 किलोमीटर दूर के रहने वाले और आए हैं घर में घुस गए FIR 15 दिन बाद घटना है 30/5 जी PW5
में से 11 तो एग्जामिन हो चुके हैं, 2 ही बचे हैं।
PW5 हाँ PW5 आयु एग्जामिन उन्होंने कोई स्पेसिफिक इनके अगेंस्ट नहीं ये जो एक हम लिखे क्रैप ये बोलते हैं कि हम उसको नहीं जानते, लेकिन एक फोटोग्राफ से पहले उस घटना का पहले का जो हम नहीं लगाए इसलिए किस केस में नहीं लगाना चाहिए था वो एक बार देख लिया जाता सारा चीज क्लियर हो जाएगा कि फॉल्स केस है या जेन्युइन केस है।
आपको अपना डिफेंस विटनेस भी देना होगा ना counsel for the petitions present will be represented the state. For the counsel for the petitions and the secretary application, the petition was taken by the UPA number 719 and 1924 by order 1916 and 2024 onwards. This means that the petition has renewed its prayer trophy on the ground of custody since 9/2024. The charge was paid on 9/2024. After holding the right transfer of the petitioner and considering the nature of the petition, there is a petitioner. Thereby, the petitioner is alleged to have been 13 years old daughter of the ground, and he also made video of the appellant's wife. The policeman is not inclined to enlarge the petitioner on bail. The records reveal that out of 13 witnesses, 11 have contributed silent. There can be no reason on the part of the state not to examine the witnesses properly. Considering the custody of the petitioner was stated directly to rely whether the remaining witnesses are properly since the constable of the state is absent, better copy of this order be forwarded to the advocate general, the office of the advocate general, and copy of this order so that the copy is forwarded to the SP of the concerned district and to the auditor of the
Matter 4, BA 6/23 of 2026.
Section 74, 126, 3, 115, 350, 351 of the US. Now the allegation is that while the informant was sleeping outside his house, he heard some murmuring. Thereafter, he found that the door was closed from inside, where her daughter was. Page 12 is beautiful. सविनय निवेदन पूर्वक कहना है कि मैं कहना है कि दिनांक 22/9/26 रात्रि करीब 10 बजे हम पति पत्नी खाना खाकर बाहर सो रहे थे तथा मेरे घर के लोग शादी में सो गए हुए थे, जिसके कारण मेरी बेटी सो घर के अंदर सो रही। लाइट कट जाने के कारण दरवाजा खुला कर सो रही थी। उसी समय घर के अंदर से घबराई हुई आवाज के साथ एक लड़का का भी आवाज सुनाई दी, तो मैं जग गया। फिर देखे कि अंदर से दरवाजा बंद था, तो मैं बाहर से now the thing is,
what is the
age of the victim as per their contention is 15 years. Now the case is that the petitioner was apprehended from the terrace of the house. Now, if your ladyship may kindly have a look to the place of occurrence, paragraph 25 of the case diary. वादी का घर मिट्टी एवं खपरेल से बना है, तो there is no chance of petitioner being caught from the terrace जब तक कि वो खपरेल को तोड़ के नहीं जाएगा, and it was not found in by the IU. Therefore, the entire story has been cooked up. The girl has not objected or raised any alarm.
As per the allegation, the informant heard some noise in the room where his daughter was sleeping, and the door was locked from outside.
मेडिकल हुआ ही नहीं।
The door was locked from inside, and when the girl opened the door, she stated that the petitioner tried to outpraise her modesty and she has gone to the press. And ultimately, the petitioner was apprehended from the press. The Royal Council has referred to Part 25 of the Constitution to say that it was made upon the terrace was made upon child youth, and therefore the petitioner could not have been apprehended from the press. The petitioner has been falsely imputed in this case. The Royal Council for the state and the government have opposed the AFB and have submitted that the petitioner was apprehended on the spot and the victim was only 2 years of age. After hearing the Royal Council for the parties and considering the fact that victim was apprehended on the spot and police was involved and he was handed over to the police. And further, the victim has also supported the prosecution case. This vote is not influenced in the last petition as mentioned.
Item 5, BS 6752 of 2026.
The relation between the petitioner deals with that on fourth pretext of marriage, the relationship was established. And the law defined that the age of the victim is 26 years and the age of the petitioner is also 26 years. They were living together since 20 traffic had been submitted. And then one new section has been added. From 6/6/2026. 64, 2M, 69, 81, 83, and 318. One section has been added and one section termination of pregnancy has been removed because there was no evidence in medical checkup, no sign of either rape or any abortion was found.
The state is able to serve notice upon the economics activity and also find contractually compliance office. With the statement of the victim recorded in section 183 BS 65/2024. Along with the case diagram, with its enclosure, including medical examination. Report is based on 19th of August. Contract date should be final.
Item 6, BS 6754 of 2026.
Yes, petition. Password.
Item 7, BS 6759 of 2026.
The house of the
Petitioner.
and
Victim is minor.
under age of 17 years, but
My date of birth is 8/12/2009. As per the state.
it was 17 years, but she beauty
voluntary supply.
And but the statement of trustee was submitted. Also, and see what the statement of the victim recorded under section 180.
That makes sense.
And see.
To 180 custody.
Yes, sir. 183 can inform him statement under section 183.
Needs to be here.
Please recovery. Yes. It's a no role to kidnap by our industry.
There is also a petition summons that the victim is 17 years of age, and it is alleged that the victim is a native girl, aged 19 years, and after petition in the house,
Yes, ma'am.
and
Some
the petition has been falsely imputed in this case. He summons that the victim wants to marry the petitioner as per the state recorded under section 118. When it comes to the state has a principle from being on the scientific age of the date of birth of the victim is 8/12/2009, and victim was recovered from the house of the petitioner as is applicable from the victim order itself. To this, the council for the petitions and itself.
Yes, sir. Can submitted.
16 years, 4 months and 11 days at the time of occurrence.
16 years,
4 months, 11 days. As per the
considering the fact that the victim is minor and she has been recovered from the house of the petitioner, this court is not inclined to revise the petition of the state. Victim examination and evaluation.
हमारे घर में आ जाएगा कोई हमारे घर में अगर आ जाएगा तो क्या बात क्या
Item 8, BS 6761 of 2026.
This petitioner place was brought up regular bail offences under section 64(1) and section 123 of BNS. It should be FIR.
Allegations are very serious. Allegations are very serious.
Yes, but not against me. In fact,
You, it was your birthday, whose birthday?
it was my birthday.
You invited her
I
by
invited
saying that all girls would be there. None of the girls were there. 4 persons were there. The visa was, there was something.
Just kindly see the confession of Danish. Everything will become clear. I had no remote idea that what is going on. Confession of Danish in the case study at paragraph 5 because I received the police papers. Because I was also not seeing the FIR, it is disturbing. What is happening in the
And
country.
after the victim reported the matter to you, you did not say that we should go to the police station or we should do something. Nothing. You said that everything will be okay.
Both victim and I, both wanted to avoid because लोग लाज दोनों को था.
Very
Victim
useful.
was
Injury managed was admitted to the hospital.
yes.
Yes, so much of injury on her private parts.
That worship the petitioner also did not realize, she also did not realize.
So what do you not realize? You are studying in a medical college
Yes, Lordship, I
and you don't realize.
We both were Lordship medical college, both are medical graduates. I got admission in postgraduate. She could not get, she was practicing, she was trying and she was staying with me only.
So how serious
my
it
room
is?
partner.
You say you could not understand. You are a person on the street.
We are not a person on the street.
Then
Just see,
Something happened
just
with
see
your
the condition of the victim.
Yes. Your Lordship, if your Lordship sees the confession of the co-accused, everything will
No,
be
we are
completed.
not bothered about the confession.
Because she is also.
Everything happened at your instance.
Nobody-
Right from day one, you were telling lies.
No, we are not taking lies from day
You
one.
told her that all girls will be there.
If
None
somebody
of them were there.
Lordship, if somebody is invited and does not come, she can.
Planned manner planned manner में से
Lordship,
और एक
both are
BD
Lordship. She is a
और BD
postgraduate
पहले
medical
बात पता
student.
कीजिएगा
She has.
सोसाइटी में क्या मैसेज जाएगा
She is a
एक
postgraduate
BD
medical student. The victim is also a medical student. Lordship.
अब BDS होकर मेडिकल स्टूडेंट को क्या पैसा कीजिएगा तो भविष्य क्या होगा
I cannot have any intention to get her make her a victim of rape. I cannot have that intention.
See, it appears that everything is honest.
But that will become clear from the confession of the co-accused. Lordship. That was first recorded.
confession statement before the police to receive
तो मेरा भी statement receipt.
और आप अगर ईमानदार हैं, आपने
Hospital में
FIR
admitted
कर दी
with so much of injuries. Yes or no?
Yes, yes, yes.
She was admitted to hospital with so much of injuries.
Yes.
Her life was under threat.
और आपके बर्थडे में ऐसा हुआ FIR आपके द्वारा होना चाहिए
You
था
can only see the report.
You should have taken steps to inform the police when she reported it to you. I can understand that initially you might not be knowing, but you being a doctor, you have no idea what has happened. You said everything will be okay.
Both the petitioner, they both became victim, and Lordship both tried to hide it from their parents.
Both became victim.
Lordship,
How you became victim?
Lordship, my only fault is I have been implicated because I did not, Lordship, want to disclose what I had also done. Both of the girls, Lordship.
You have not undergone it.
Yes, Lordship, I have also done.
You have also filed an FIR.
I did not file an FIR, only Lordship to say.
What is this? You have undergone sexual assault and you will not file an FIR. Being a medical doctor.
Being many things Lordship, in the society, Lordship, even the victim would not have instituted an FIR. Both know what had happened with us.
Victim would not have been
Lordship,
instituted an FIR.
victim herself says that had she not suffered, Lordship, when we see the FIR, she also herself says that is a natural conduct, Lordship. Had she not suffered that injury, she would not have disclosed to anybody. And Lordship, take into consideration, I had no remote idea that what is going to happen. Even the victim does not say in the FIR that I had any intention that anything, and that there is no medical report, Your Lordship, showing any such injury on the. Yes, she has been. No, it is nobody says that she has not undergone a sexual.
You know, there was so much of injury. She was forced to be admitted to a hospital
She was
with
forced.
so much of bleeding on her private
Yes.
parts.
But kindly see.
What do you mean?
Lordship,
It was absolutely a case of brutal rape.
yes, and she was intoxicated.
Yes.
She was under the
If she was under intoxication, what was you doing
Lordship,
in your own house?
Lordship, she herself said it is not my house.
Wherever
Yes.
it was your birthday party,
It was my birthday party.
Right.
That is all. Yes.
right?
Lordship.
And then the culprit, right? The person, the rapist, right? He entered into her room.
Her room.
She was there in the room,
Yes.
locked from inside, and committed the offense.
Nobody knew that what has happened.
What do you
Lordship,
mean
so
nobody knew?
Till in the morning, she
No.
herself says in the morning she disclosed to me. She herself says, Your Lordship.
I fail to understand.
Lordship, there has been a
It was
negligence.
your birthday, you were throughout present, and you do not know what happened to you.
It is her case in the FIR. Lordship, it is true that there has been a negligence. I cannot
No,
defend it.
this is not a case for me. I will not grant.
Lordship, I kindly see this other hospital report, Your Lordship, that is a
We
case.
don't bother about the report.
It is a case where both the girls have been made a victim of circumstances. Lordship,
No, that is not the case. You are not watching the FIR that you have been raised.
all 90% of the cases, it is a fact, Lordship, it is there in the reports also. Cases are
Not
not being
expected from the
registered.
medical officer.
Yes, Lordship.
Not expected from the medical.
Considering the social status, family reputation, Lordship, many times, Lordship, it is not done. Many times, Lordship, they try to hide because even their parents might not be knowing, Lordship, that they have gone for a birthday party from the hostel. Many times, parents are not told, Your Lordship, and for that, Lordship, she has already suffered a detention, Your Lordship. Her entire career is at stake.
Yes. The life of the victim is all the more at stake.
Yes,
Her
Lordship.
life is ruined
With
completely.
all sympathies to her, Your Lordship, and only thing the difference is, Lordship, this girl did not institute it. And and they are both victims. If your lordship sees the manner of occurrence and why it has been done and the manner in which we were both allured, your lordships. It was my birthday. I invited my room partner. I invited others, did not come, and these 4 persons came. I was taken as per the statement. I was taken in another room. That is the confession of the.
You were taken in another.
Yes, that is the confession of the co-accused.
Just a moment. And who raped you?
Actually, they say I went with the boy named Sadaf.
We never see
But
services.
lordship only consider the detention and the lordship.
I have full sympathy with you, but law cannot sympathize with people.
It is also not a case, lordship, that I had or there was any conspiracy.
All of us, all of us.
अभी ये conspiracy कहाँ से इनका
The transfer of the teachers and the teacher is in custody since
May I?
2026.
Yes, one. The lordship permits the liberty to renew after some time, so that lordship she can suffer sufficiently, and lordship that whatever time lordship says, I will give her with the liberty to renew.
After hearing the lawyer transfer of the parties, the school for the time to realize the petition on the transfer of the petition seeks for the to withdraw this paid application. And this too.
Lordship say whatever time you say, I will withdraw it with the liberty to renew after that. Lordship put it in my own mouth.
Some said, we shall review the prayer from the after some time. Particularly after the victim is examined. It's the examination. Then we will see.
दोनों लड़के दोनों मेरिटोरियस थे मेडिकल में एडमिशन होना फिर पीजी में एडमिशन होना इज हॉट टफ उसमें भी ये क्वालिफाई I talked with the parents. They would say that we were also shocked when she was taken in custody.
Everybody will be shocked because parents would not be knowing that you are in a company of such qualified persons.
When the parents talked with him, she said.
And you say that you have also been raped, but you do not file an FIR.
Lordship,
Why did you file an FIR? Being a medical student, you will not file an FIR.
they
It
tried.
is unbelievable, Mr. Das.
Lordship,
It's completely unbelievable.
I talked with him. I went. The parents
If
did
a
not agree.
medical student will not institute an FIR, who
Yes, it is
else
true.
would?
As a counsel, I say that they
Who
should,
else would
they
institute
should
an
have
FIR?
done. But the thinking was first my parents will come to learn. That was the thinking of the child. And secondly, my reputation of my family. Yes. And secondly, my entire family stake reputation will be at
Yes,
stake.
it
That
is
was
already gone.
now it is everything on that time. That was the thinking on that time. Now everything is gone. But if parents cannot show their face anywhere. The PT condition of the parents have seen.
After the girl is examined, the
Yes, sir.
Item 9, DS 6764 of 2026.
If I am was my mother, then there is a relation with the petitioner, daughter, worship. So make I call for the base statement of the victim, which is required.
Charging file.
The charge sheet file.
The council for the state is directly to serve notice upon the victim who is also upon the informant of this and 5 counter-affidavit amendments. If that is directly along with its enclosure, including a medical report, medical examination report of the victim, if any record of the consent board, and also the statement of the victim recorded under section 126. From 19th August, contact
Item 10, BS 6765 of 2026.
In this case, FIR laws in under section 103 sub
Did you move earlier?
Lordship.
Did you move earlier?
No,
You just look at paragraph.
this is wrongly mentions thereafter deleted Lordship.
Thereafter deleted, it's not deleted.
So. But
You have
earlier
not-
I have not wrongly mentioned Lordship.
You have mentioned it, you have to rectify it.
Lordship.
You are going to-
I will tell
And
you.
what about that there are other co-accused also in this case?
No, only one.
There's only one,
Only
one
FIR.
accused.
Only the one accused, the petitioner was.
Petitioner is the only accused, there is no accused called Manoj Ram,
Not. In page 9. Page 9.
Sheila Devi, they are
No.
not accused in this case?
No. In this case also may kindly be called for the postmortem report also, because there is a allegation of
पहले हम इसको ठीक कर लिया।
हम इसको ठीक कर लेंगे मीन टाइम में काम
अभी कुछ नहीं।
ठीक
हम इससे परेशान हो गए।
है ना, ठीक।
कोई उसका
So-
statement देता है, आपका वो जो बिल ऑर्डर है उसका नाम देता है।
निश्चय हम इसको
We
करेंगे
spend 10 minutes in the morning to find out कि क्या हो रहा है। ऑफिस में क्या हो रहा है कि आपकी
गलती
गलती है कि
दिस इज
हमारी
माय
गलती है।
फॉल्ट दिस इज माय at the time of drafting this I will correct also.
Also for the petition submits that some incorrect statement has been made in paragraph 2 of the bail application. We base on some planning to take up the next steps. What are they doing?
I will file supplement
What are they?
next week
Post on next Thursday.
Item 11, BS 6767 of 2026.
Alleged offences under section.
How many antecedents do you have?
One.
Investigation is going on or charge has been submitted?
Charge sheet will be submitted within 10 days. So I was playing that with the matter.
For the
Cyber
council,
matter.
for the level councils, dealing on behalf of parties. The council for the petition says that the petitioner has one criminal antecedent related to cyber offense and he is in custody since 2026. Upon inquiry of the school decides that charge sheet has now been submitted. However, it is likely to be submitted within 15 days. After hearing the council for the state of the case of the after hearing the level council for the parties and considering the fact that there is right allegation of recovery of SIMs and mobiles.
litigation 2 mobile phones 1 SIM card but that has not come in the diary that is there any victim or not there
Two mobile and one SIM
yes
standing in the name of other persons.
that
Your one. Stand from the possession of the petitioner and investigation is still going on. And as per the review order, since recovered were issued in the name of different persons and several e-wallets were found to have been created.
no that has not come in
As per the review order, the investigation is still
that is
going
why I
on.
am saying that
Much material is likely to surface. And the petitioner already has a.
no victim has turned up litigation till date
अभी कहाँ से होगा इन्वेस्टिगेशन चल ही रहा है
No.
और भी नो
that is why I am saying it is like a charge sheet is submitted
That's a petitioner on bail at this stage. The petitioner will use prayer for the after 6 months.
litigation related to 3 months
ये
Item-
कोई बजाज चल रहा है
Item 12, BS 6768 of 2026.
एक्सीडेंट होता है उसको 6 months का ऑब्जर्वेशन देते हैं आपको अलग से नहीं
and if permitted to return the prison
council for the petition seeks permission to withdraw his bail application. Permission is accorded. This is section. State has no objection.
Sign comes in. Item 13, BA 6774 of 2026.
The senior counsel is out of stage on the occasion of Guru Purnima, he went to Banaras.
Council for the Petitions Department. On the ground of first reasons that we This is based on 30th of August.
Item 14 BS6.78 of 2026.
Yes.
System of voting the house of the petitioner as made and petitioner has completed it and agreed that no thereafter presentation.
There is valid allegation.
So kindly come to page number 24 paragraph number 13. Now charges in claim 3 witnesses out of 12 have been examined. Witness specifically stated paragraph number 30 page number 24. कंपनी में काम करता है संतोष में ड्यूटी के लिए 6 बजे जाता है रात में 10 बजे वापस मैं संतोष घर पे घर काम करने के लिए सुबह 9 बजे आती तो 4 बजे आ जाती सुबह काम करने जाती सारी काम कर जाती उसमें संतोष में ड्यूटी में रहता
आगे का सेंटेंस नहीं पढ़िएगा
रहता
और आगे का सेंटेंस पढ़िए आगे का सेंटेंस पढ़िए
लेकिन कभी कभी संतोष जल्दी छुट्टी मिल जाती है तो मैं इसे खाना पहुंचाने लगी मैं सब करता the petitioner was staying with her wife and he was working in a company
तो वाइफ के रहते लेट नहीं होता है क्या यस वाइफ के घर में रहते लेट नहीं होता है डोमेस्टिक हेल्प के साथ क्या समझाना चाह रहे हैं
because he was in day duty on
तो ये नंबर 6 double 78 of 886 what the very council for the on the office the very council for the petitions on the side of petition and possibly individual in this case and the victim is said to be a domestic help in the house of the petitioner and the petitioner used to reside with his wife and therefore there is no likelihood of commission of rape in the house. The council of the state has accused of rape and has submitted that there is direct and specific allegation against the petitioner. And trial is going on out of 12 charged cases. 3 have already been examined. Including a victim, and victim has supported us. After hearing the victim was made, after hearing the counsel for the parties, and considering the direct and specific allegation made against the petitioner, and also the fact that prior to this ruling, the school is not inclined to embrace a petitioner only. Either the state is directed to improve and the remaining witnesses are not introduced before. Also, the state is directed to conclude this order and the right to proceed and also be done.
Item 15 BS6791 of 2026.
Prayer for regular bail on behalf of brother-in-law Devat and father-in-law in a case of section 80 of the BNS. That is 304B of the previous section IPC. The allegation is shortly as per the FIR. The informant is one Ashok Mathur. He alleges कि निवेदन पूर्वक कहना है at page 22 I am reading and pressing the FIR. Subject मेरी बेटी को दहेज को लेकर जान से मार देने के संबंध में बात है। निवेदन पूर्वक कहना है कि मैं अशोक माथुर पिता सचिन सच निवासी सचिन सच बेंगाबाद जिला गिरिडीह का निवासी। मेरी बेटी मुंद्रिका कुमारी उम्र 20 वर्ष की शादी हिंदू रीति रिवाज के साथ पर्सन कोटी के कैलाधाम निवासी पंकज कुमार वर्मा इज द हस्बैंड। पंकज कुमार वर्मा पिता परमेश्वर महतो पिटिशनर बिफोर योर लॉर्डशिप के साथ हुई थी। पिछले वर्ष 22 फरवरी 2023 को अपने क्षमता के अनुसार दान दहेज का उपहार देकर शादी की थी। शादी के बाद करीब 2-3 माह तक सब ठीक ठाक चल रहा था। बाद में मेरी बेटी ने मुझे कई बार फोन के माध्यम से वह हमारे घर आने पर बेटी बताती थी कि मेरे पति पंकज कुमार वर्मा पिता परमेश्वर महतो पिता सचिन सच सास उर्मिला देवी पति परमेश्वर महतो देवर निर्मल वर्मा इज गुरुपुरिया एंड परमेश्वर महतो। ये सभी ने मेरी बेटी को दहेज के रूप में 3 लाख लेकर व्यवसाय करने हेतु एवं क्लासिक्स मॉडल का एक बुलेट की मांग मुझसे अपने भाई से लाने के हेतु किया करते थे। दहेज पूरा न देने से मेरी बेटी को ससुराल वालों ने लगातार झगड़ा झंझट करते आ रहे थे। नहीं देने पर मेरी बेटी को जान से मारने की भी धमकी देते रहते थे। मेरी बेटी मुझसे दहेज की मांग को लेकर मुझसे बात करने के क्रम में रो कर काफी परेशान रहती थी। इसे लेकर मैं अपने दामाद पंकज कुमार वर्मा एवं समधी परमेश्वर महतो से आग्रह भी किया करता था कि मैं एक मजदूर हूँ, मैं रांची में किसी दुकान में मजदूरी करता हूँ और अपना जीविका चलाता हूँ। मेरी आर्थिक स्थिति ठीक ठाक नहीं रहने के कारण मैं दहेज नहीं दे पाया। इन ससुराल वालों के द्वारा भी दहेज की मांग फोन के माध्यम से किया करता था। नहीं देने पर की बात कहने पर मेरी बेटी को जान से मार देने की धमकी दिया करता था। 2 दिन पूर्व भी मेरी बेटी के साथ उन लोगों ने मेरी बेटी को मारपीट किया करते थे, जिससे सूचना दिनांक 25/7/24 को मेरी बेटी ने फोन से बताई थी। आज सुबह 6:30 बजे के पूर्वान्ह मेरी समधी ने मुझे फोन पर बताया कि आपकी बेटी फांसी लगा ली है। मैं व्याकुल होकर अपने घर वालों को कैलाधाम जाकर जानकारी देने को कहा। करीब 1 घंटे बाद मेरे पिता ने मेरी बेटी की हत्या की सूचना मिला पाकर मैं रांची से पर्सन कॉपी आया। मैं अपने लिखित आवेदन को दिया। This is the case. Now kindly have a look to page Annex 3, page 24. This is the order granting bail to the husband.
You are not a party to this trial of the husband. Are you facing the trial of the husband?
Trial तो जेल में है।
नहीं, आपका तो कस्टडी भी है 4/6/26 से। 4/6/26 से आप कस्टडी में हैं। ये ट्रायल आप नहीं फेस कर।
4/6/26 से कस्टडी। Now the order says granting
आपका ट्रायल स्प्लिट हो गया होगा। उनका ट्रायल स्प्लिट हो गया होगा।
नहीं स्प्लिट उसी ट्रायल में
कैसे आपका चल रहा है?
तो कस्टडी में है।
आपकी कस्टडी में है 4/6/26 से।
जी।
और ये जो है बेल ऑर्डर में
हस्बैंड का ट्रायल चल रहा है।
हाँ अलग से चल रहा है, आपके साथ नहीं चल रहा।
Yes, right. Husband and the mother-in-law who has since been granted bail by
उन
this.
लोगों का ट्रायल चल रहा है।
जी उन लोग का ट्रायल चल रहा है।
इसमें विटनेस के 3-4 एग्जामिन होते हैं।
जी। I have
स्प्लिट हो गया है।
जी। So far the husband is concerned who is facing trial, having been granted bail, this honorable court observes in para 4. The petitioner happens to be the husband of the deceased Mundrika Kumari, who died in her matrimonial home within 7 years of her marriage due to asphyxia because of hanging. Then, para 7. Considering the fact that apart from the HMR, no other mechanical injury was found, so 20,000 the bail. Now, so far mother-in-law is concerned, namely Urmila Devi, इस पर है कि जनरल ऑमनिबस एलिगेशन है.
एक साल से ज्यादा का कस्टडी हो गया था. ट्रायल वाज in progress but the witnesses were not being examined. That was the reason for grant of bail.
Again, they are different from the. Now, what my submission is to this honorable court, that the father-in-law and the brother-in-law, who is a nearly aged about 20 years, was prosecuting his studies, and father-in-law is aged about fairly elder man, 50-51 साल का. इन्होंने सरेंडर किया है. Paragraph 1 itself I have indicated the date of the
शादी हुई है 22 लोग 23
within 7 years.
within 7 years within
The parameter of law is within 7 years.
that's
I
right.
don't deny
Within
the
बहुत
period.
short time. You
जी,
just see
short time.
25-7-24 को she died.
The facts are there.
और आप लोग सब रहते हैं वही साथ में. ऐसा तो नहीं है किसी का brother in law.
But ठीक है. तो है तो
तो
है. We stand on the footing same as the other.
not as आपका custody बहुत कम है. तो custody के ground custody ground पे 1 साल से ऊपर हो गया था custody के आपको absolutely आपने 1 साल से तो जरूर ज्यादा है.
एक verify.
देखिए उनका बेल रिजेक्ट हुआ था 18/12/24 को. उसको पहले से ही कस्टडी होंगे 2-3 महीना ना. और 19/9/25 को बेल.
In this case, your lordship, I received a transfer on behalf of him. I will file today.
इतना सुनने के बाद क्या करूं? फाइल करिए इस पर रिव्यू का प्रोसेस.
Yes.
Now I leave it to the discretion of the honorable court.
थोड़ा कस्टडी होने दीजिए इसको.
ठीक है. इसका टाइम दे दिया.
हम कुछ क्या चाहिए
आपको कम लग रहा है तो sufficient टाइम दे.
और दिल्ली काउंसिल से पहले में ग्राउंड
यानी एलिगेशन तो सब पर omnibus है और जनरल एलिगेशन.
the petitioner submits that there is genuine and omnibus allegation upon all the accused persons. The petitioner, though they are all named in their father, the petitioner number 1 happens to be the brother-in-law and petitioner number 2 happens to be the father-in-law of the deceased, who was married to the co-accused on 22/2/2023 and she died in a matrimonial home on under unnatural conditions on 25/7/2024. The petitioners are in custody since 4/6/2026. The Learned Council has referred to the bail application of the accused Pankaj Kumar
Bail
Verma,
orders.
bail orders of the accused Pankaj Kumar Verma, who happens to be the husband of the deceased. In bail number 5693/2025, whereby he has been granted bail by order dated 19/9/2025, although his bail application was earlier rejected by order dated 18/2024. He has also relied upon the bail application bail granted to the accused Urmila Devi, the mother-in-law of the deceased, who has been granted bail by order dated 25/3/2026 on the ground that the husband of the deceased has already been released on bail. During the course of hearing, it transpired that the husband of the deceased was already facing trial and primarily on the ground of custody, he was enlarged on bail by this court as only 3 witnesses were examined till 19/9/2025. After the council for the state as well as the employment sponsor the employment. And have submitted that.
We have taken the risk of submitting something.
Just in case, 2024, the petitioners being father-in-law and mother-in-law are in custody since 4/6/2026. After hearing the legal counsel for the parties and considering the fact that the deceased died in a matrimonial home within 1.5 years of marriage. And it is not in dispute that all that the petitioners have been residing with the deceased. There is an allegation of demand of dowry of 3 lakhs cash and 1 motorcycle. In view of the allegations, this court is not inclined to realize that petitions in the stage. At this stage, at this stage,
इसको एडजर्न भी कर दिया जाता है.
at this stage,
हाँ हाँ.
Item 16 PA 6799 of 2026.
नहीं ऐसा किया जाए. एक मिनट. Subject to your lordship's permission. Trial court will be directed to expedite the trial. now तो हम उसी ट्रैक में हैं.
ये चार्ज भी नहीं ट्रेड हुआ.
चार्ज नहीं.
हमें ये बात तो हम कैसे डायरेक्शन देते हैं.
ठीक है. चेंज सिचुएशन होगा.
सिचुएशन
स्टेट
होगा.
चेंज
दो
करेगा
चार
उसके यहाँ.
2-4 विटनेसेस एग्जाम हो जाने दीजिए.
जी.
मटेरियल विटनेसेस एग्जाम
नहीं ठीक.
आज तो आपके लिए इम्पोर्टेंट है. Yes, please. Yes, petitioner.
Delay of the trial. Allegation page number 15. 5 days. First offense 27/4/2026 को. Second
FIR किसने किया?
mother की.
मदर ने किया. बताइए होगी वो. उनको रहती थी माइनर या उसको रहती थी तो मम्मी कुछ बताइए.
ये जो मेडिकल बता दो कि 17+
आपका चार्जशीट तो हुआ है ना.
चार्ज फ्रेम पे हो चुका है.
आपका डायरेक्ट एलिगेशन.
ये डायरेक्ट एलिगेशन है लेकिन 27 को पार्टी में नाच गाना हो रहा. उसके बाद हम ले गए हैं. कोई इंफॉर्मेशन नहीं, कोई कुछ नहीं. फिर 28 दोबारा 28 को भी हम ले गए हैं. कोई इंफॉर्मेशन नहीं. 29 को वापस घर गई हैं. तब उनकी माँ पूछी है. फिर 30 को भी थाना 30 को FIR. फिर 1/5 को FIR.
इतना तो बहुत नेचुरल है.
64 स्टेटमेंट भी देखिए तो लाया नहीं.
It is a case of aggravated penetrative sexual assault.
लेकिन दोनों एक
And the
दूसरे
order reveals that 183 में she has supported this.
183 में लेकिन दोनों एक दूसरे को जान रहे.
तो जानने से क्या हो गया? माइनर है ना. कितना उम्र है उसकी?
आई तो आपको 16 ईयर और मेडिकल 17+1 है.
मेडिकल 17+1 में आप अपने हिसाब से चलिए. हमारे हिसाब से नहीं चलता है 17. और आपकी उम्र कितनी है? 28 साल. थोड़ा मैचिंग भी तो एज होना चाहिए ना प्यार करने के लिए.
क्या करने के लिए
लेकिन
लेकिन मेडिकल में 18 आ रहा है उसको.
ये नंबर 6799 of 2026. The heard the learned counsels appearing on behalf of the learned counsel for the petitioners on its side. The FIR has been lodged by the mother of the victim, and the first incident is of 27/4/2026. But the FIR has been lodged on 1/5/2026. So there is direct allegation against the learned counsel for the state has opposed the prayer for him and has submitted that there is direct allegation of rape upon the minor daughter of the informant. And the victim was minor, and she was aged around 16 years on the date of offense. So does everything.
Yes, ma'am. That has been given to you.
And the petitioner happens to be 28 years of age, as per the way application itself. She says that, as per the approval order itself, the victim has supported the allegation made under section allegation in a statement made under section 183 of the ABS. Charge sheet has been submitted and there are altogether 12 prosecution witnesses.
Charge him
12 prosecution witnesses. This constitutes the petition submits the charges of the
charge date 18/6/2026.
but no witness has been established. After hearing the legal counsel for the parties and considering the valid allegation against the petitioner, which is said to be supported by the statement of the victim recorded on section 183 basis. As per the appeal order itself, this court is not inclined to renounce the petitioner. However, the state is directed to ensure that the witnesses are also the state is directed to resolve with the director prosecution and also with the SPO of the concerned district. FSL report is made. We also forward FSL has something. Many. So,
At this stage,
so,
नहीं तो victim का examination के बाद
हाँ कराइए ना तो हॉस्टाइल होती है तो आप आइए ऐसा थोड़ी है कि हम आपको देंगे ऐसा क्लोज माइंड नहीं
close नहीं
let us see how the trial progresses.
Item 17, DA 6800 of 2026.
Case number 669 and 89. What is my submission on this diary for the reason both petitioner as well as victim has come in case diary that both are married persons. The age of the victim here is about 25 years that she is stated in the FIR. Now she says that
Upon the informant who also happens to be the victim of the case. And file a comparable on minutes. Transfer the petitioner has specifically submitted that the petitioner is a married person having 2 children and the victim was also married.
there was ongoing affair as per
And there appears to be consensual relationship between the petitioner and the let the case diary along with its improvements we call for the consent and also the statement of the victim recorded in section 183. The contract will be filed on 14th August 2019.
Item 18, PA 6803 of 2026. Item 19, BA 6808 of 2026.
First information report was brought on the basis of a complaint which carried to the FIR under section 144, 148, 149, 307, 380, 422, 376, and 120D of the IPC. After investigation, the charge sheet is submitted against the petitioner and other accused person merely for the offence under section 341, 323, 564, 506, and 34 of the IPC. Yes, yes.
Cognizance has been taken.
Cognizance subsequently cognizance has been taken.
376 and
Yes, yes, that I agree.
charge has been taken under which section?
The charge is still not been clear because it is just the center the center been taken into custody. So now my submission for lordship is that.
You were earlier granted bail.
Yes, certainly I was earlier granted bail.
Actually, because new section was added.
New section that is the point that I want to submit.
New section was added
Yes.
Ultimately, your non-bailable warrant was issued.
Yes, because there is no execution report.
We are not concerned with
No, certainly, because of there is no execution report of the warrant of arrest for any sort of the process. Now my submission for lordship is that the lordship has
that.
kindly
Non-bailable warrant, etc. were issued.
yes, but execution.
And you have been arrested.
Yes. Now my submission for lordship is that lordship has likely pointed out that since the petitioner was granted bail, since the offence in course of investigation found to be the bailable offences, and now this section has been changed after taking of the cognizance. Now, whether without cancelling that bail bond,
You see, we are not in a stage of washing.
no, it is not the case of
If you are agreed by the process adopted by the court, you have to file a court execution. And
no, now I am on the question of bail.
now you are on the question of bail. So
Certainly, I am on the question of bail. See, without cancelling my bail bond, earlier bail
bail
bond,
bond was cancelled.
no, bail bond has not been cancelled. That is the case.
See, the accused persons were summoned.
Yes, summoned, but that bail bond is not cancelled.
But you did not appear, no?
But
You did not appear.
unless and until lordship I got any notice.
See, if you are agreed by the process, you have another bail.
No, certainly that is another limit. That is what the cost. I am not challenging the costing order. Cognizance
So
order.
you will just focus on your bail application.
I am focusing on the bail order. I am focusing on the bail order. Without cancelling my earlier bail bond, I have taken into custody.
No. Yeah.
Yes.
I'm just, if your custody is absolutely extrajudicial illegal, you have a remedy, not in a bail. Then you proceed and file your appropriate petition, challenging the order, whatever orders are there.
No, because now my bail petition has been rejected. Earlier I was on bail.
See, I will only consider your bail act.
Certainly that I am also submitting to the lordship.
But whatever procedure has been adopted, if you want to challenge any of those procedures, then you have another bail. जैसे कि 80 to 83 का प्रोसेस हो जाता है तो वॉशिंग होता है ना फाइल ठीक है वैसे ये यहाँ पे नहीं हम ये ऑब्जर्व
नहीं यहाँ पर apart from that what the merit of the case is concerned हाँ merit of the case is concerned no now merit of the case is concerned in the course of investigation the supervision of the SDPO and the SP it has found that the informant has knowingly and purposely lost the case and apart from that consequent to the first information report the complaint is lodged on 3/8/21 for the occurrence of 23/7/21 and 24/7/21. It took the shape of the FIR on 11/5/22. 11/5/22 it took the shape of the FIR. There is a delay in lodging the first information report and that is the reason in the course of investigation it is said that had it been a case of gang rape then the informant would have reported the matter before the PS. Though in the complaint the informant says that she had earlier made complaint online, but in the investigation it was inquired and yes in the investigation
she has also given a statement. Her statement has been recorded and it's 164. She has made clear and against you regarding you.
but apart from that the other
Delay is another thing. Time bar हो गया क्या?
time but लेकिन और time but टाइम बट नहीं बट ये डेलिबरेट है ना डेलिबरेट एंड आफ्टर थॉट तो हो सकता है आया कि लैंड डिस्प्यूट है इन लोग के बीच में डायरी में आया है दैट्स ऑल द रीजन वो एक बार चार्जशीट देख लिया तो चार्जशीट पढ़ लिया था कि चार्जशीट में क्या बोल के वो दिए पेज 25 क्या बोलकर दिया गया है व्हाट इज द समरी ऑफ द इन्वेस्टिगेशन जो आया है पेज 25 में देख लिया था ये कांड पांडेमी सच एंड सच के द्वारा जिला ट्राइब्यूनल दायर न्यायालय परिसर 646 के आधार पर सभी अंकित प्रभावितों के विरुद्ध घर में घुसकर मारपीट कर जेवर रुपया लेने एवं बलात्कार करने का आरोप पंजीकृत किया गया। कांड के अनुसंधान के क्रम में घटनास्थल का निरीक्षण बाधिनी साक्ष्यों का बयान लिया गया। कांड के पीड़िता को चिकित्सीय जांच हेतु चिकित्सक के पास ले जाया गया किंतु चिकित्सक के समय पीड़िता द्वारा अपनी चिकित्सीय जांच करने से मना कर दी। तत्पश्चात पीड़िता का माननीय अदालत 164 के अंतर्गत बयान लिखा। इस कांड में अनुमंडल पुलिस पदाधिकारी राजमहल का पर्यवेक्षण एवं पुलिस अधीक्षक साहेबगंज का प्रतिवेदन 2, 3, 4 प्राप्त है तीनों। अब तक के अनुसंधान एवं प्रतिवेदन 3 ने इस कांड को धारा 341, 323, 504, 506, 34 आईपीसी विभागीय दंड के अंतर्गत सभी प्राथमिक विरुद्ध दर्ज पाया गया। इस कांड के तीनों प्राथमिक के अभियुक्त को दिनांक तो यथार्थकर माननीय ज्ञान को प्रसारित किया गया, माननीय चीजों को भवन भरवाकर जवान को मुक्त किया गया। अतः इस कारण का अनुसंधान प्राय सभी बिंदुओं पर पूर्ण के पश्चात बड़ी पदाधिकारी के आदेश के आलोक में इस कारण में धारा 341, 323, 504, 534 भारतीय दल के अंतर्गत
Cognizance order challenge करिए, cognizance order challenge करिए, 376D का केस नहीं बनता, ये सब करिए। जेल में तो हमको जो है हम वही देखेंगे।
तो फिर उसका ये डायरी का तो बात तो और भी स्टेटमेंट देख सकते
क्या
हैं।
है? क्या स्टेट?
तो डायरी में अदर विटनेसेस क्यों बोला कि व्हाई द केस हैज बीन फाइल्ड, ये भी तो कॉग्निजेंस हो गया है। आई कैन नॉट डिनाई फ्रॉम दैट कि कॉग्निजेंस हो गया।
बाकी दोनों का
बाकी दोनों पर भी सब लोग प्रोसेस इशू हुआ है जो ये हम नहीं ये हम कभी रिसेंटली इसका इंटर ऑर्डर सीट हम मंगवा इसी चीज को देखने के लिए कि बाकी लोगों पर भी प्रोसेस इशू हुआ है। इसका एक बार केस डायरी पे देख लेते हैं, लेकिन नहीं मेरे पर कोई एग्जीक्यूशन रिपोर्ट नहीं है।
आप तो पकड़ा रहे हैं ना,
लेकिन एक भी नॉन अवेलेबल वारंट का या समन्स का हमको एग्जीक्यूशन नहीं है। एक भी एग्जीक्यूशन
एनबीडब्ल्यू इशू हुआ है आपके अगेंस्ट में।
ठीक है, हम मान रहे हैं कि एनबीडब्ल्यू, पर हमारे ऊपर एग्जीक्यूशन तो होना चाहिए था। एग्जीक्यूशन रिपोर्ट नहीं है।
एनबीडब्ल्यू का इशू हुआ, उसको चैलेंज करो।
उसका एक्चुअली नहीं, एग्जीक्यूशन होगा तब हमारे ऊपर के
चैलेंज करो।
नहीं,
ऑर्डर शीट में है ना, प्रोसीडिंग में है ना।
हाँ प्रोसीडिंग में है, लेकिन हमको एग्जीक्यूट तो होगा ना, हमको रिसीव तो कराएंगे। हमको रिसीव लेके अचानक हमको अरेस्ट करके लेके आ गए, हमको रिसीव तो कराएंगे। हम ये इंटर ऑर्डर सीट हम सप्लीमेंट्री में लगा देते, जो हुजूर इस बात को मान रहे हैं कि हम एनपीडब्ल्यू इशू है इसीलिए तो हम अपील नहीं किए हैं कि मेरा बोनाफाइडी के लिए हम लगा देते इंटर ऑर्डर सीट। नॉट 9 डेज नहीं मतलब 24/7/21 को घटना है, नॉट 12 दिन तक ये है आप कंप्लेन लॉन्च करने के लिए, और एफआईआर लॉन्च हुआ है 11/5/22 को, लगभग 9 महीना के बाद। एफआईआर एनेक्स 1 पेज 12 में हाँ कंप्लेंट हाँ कंप्लीट की थी 3 आर्टिकल्स को।
The alleged incident had taken place on 23/7/2021, and the complaint case was filed on 3 April. And therefore, there is a delay of 9 days in filing the complaint case. Correct? 9 days. No, we never been at it. The land council for is that after investigation, charge sheet was submitted under section 341, 323, 504, and 506/34 of IPC. And the petitioner, along with others, were granted bail earlier by order dated 19/4/2023. However, the court has taken cognizance under section 323, 341, 504, 506, as well as section 376D/34 of IPC. And the accused persons were summoned, although in the improved order it has been mentioned that bailable warrant and non-bailable warrant were issued, and on the basis of non-bailable warrant, the petitioner has been arrested and remanded to judicial custody on 7/5/2026, but he was never served with the copy of the bailable warrant. The learned counsel says that the improved order also reveals that other 2 persons are still awaiting for the process of the service that the petitioner has been falsely implicated in this case, and the cognizance has been already taken under section 376D of IPC.
And without considering before I have been taken into consideration.
And without, we can't without cancelling the wrong or taking into custody.
Item 13.
Somebody said the petitioner was taken into custody without cancelling his. The legal counsel for the state has opposed the bail for bail and has submitted that the cognizance was taken and that initially the cognizance was under bailable sections. And since non-bailable section of 376D/34 was added, therefore, upon summons, the petitioner was supposed to appear before the court and wait for bail again. But the petitioner did not cooperate and he was arrested. And also something that the petitioner has not even annexed the copy of the omniscient to demonstrate as to how bailable, volume, and non-bailable volume for this condition that is. After hearing the legal counsel for the parties and this court finds that the audit between bodies is stated in 5/2023 has been placed on record, which reveals that the statement of the victim was recorded under section 164 CRPC, and she had reiterated the fact of commission of rape by the three accused persons one by one. In such circumstances, cognizance was taken under section 341, 323, 504, 506, 373/54 IPC, and the date was fixed for the appearance of the accused persons. The order taking cognizance itself reveals that the victim had made direct allegation of rape against three persons, including the petitioner. This court is not inclined to enlarge the petitioner on bail.
And this is
It's already finished.
Item 20 BS 6991 of 2026.
I'm not learned it, specific is not available in Mrs. India's system.
sees a pregnant lady of 7 months mother says also admitted in the hospital in this case of he had as per the of 7 months.
And she was not happy with the honest.
This meeting was recovered one by other person.
She was not happy with the honest. Asking to join. She wants to join everyone.
Yes,
Are you going to join?
yes.
250 months.
Item 21 BS 7122 of 2026.
Where is the state? Are you there for ACP? Are you there for ACP in this case? We should not join.
Item 21
Prohibits ACB.
Vishwanath Roy.
He's not legs winners, but I also represent the SCB winners with beef winners.
We are given an observation that they will renew the pay for the doctor billing and charges.
So therefore nothing remains since there is my lord's order.
The court used as a reduction. Court used to be here. Yes. Custody कब से है सर? 22 6 महीना हो गया और
TMPS
तो चार्ज फ्रेम हो गया ना जैसे सब्सिट्यूशन है ना सैंक्शन तो आ गया है उसके बिना तो नहीं होगा आपका कोई ये नो सैंक्शन हो गया है सही से
कॉम्प्लिकेशन के समय ही आ रहा है
कितने विटनेस है और बिल्डिंग काउंसिल से ये लोग बिल्डिंग काउंसिल को पब्लिक सर्विस है the bill application of the petitioner was rejected earlier in DA number 1960 of 2026 by Government DT.30.07.2026. However, because observed that the petitioner may is paid for the after 20 the level constitutes that the charge has already been paid by Government DT 9/7/2026, but no prosecution witness has been examined so far. And there are 8 witnesses. The petitioner is in custody since 2026. Once the summons at the court has been enlarged on bail by this court in DA number 2710 of 2026 by order dated 23/4/2026. The learned counsel for the state has opposed the prayer for bail. However, the other submissions made by the learned counsel for the petitioner is not in dispute. After hearing the learned counsel for the parties, this court finds that an observation was made by this court that the petitioner may renew his prayer for bail after clearing of charge. Now, the charge has already been claimed. The petitioner is in custody since 2026. And no prosecution witness is safe to have been examined before the trial court ended. The petitioner will tell to be अभी तक भी नहीं हुआ सर अभी तक भी नहीं हुआ
Permission item 22 PA 3845 of 2022.
It's not in compliance with the order dated 13/7/2026. Now, I have filed an affidavit, belongs affidavit stating that this petitioner having surrendered and he is now is in jail on the 16/7/2026. What your name? Yes, DA number 3845 of 2026. The counsel for the petitioner, the counsel for the respondent. Summons that the petitioner has now surrendered and he is in custody since 16/7/2026 in Central Jail. Now, ma'am, do you have any instructions? The learning counsel for the petitioner summons that she has no instructions. Likelihood of justice. In such circumstances, this state application is dismissed as not best. remitted back as they were directed to submit and bail application was to be
Item 23, ABA 370 of 2026.
And we should in this matter have this assignment.
Thank you.
And we should in this matter, the last revision we had asked us to investigate in the, to cooperate in the investigation operation. We have appeared on this side date 2097.
Where is the constable is? They are filing supplementary.
No, I did
Not
not.
yet.
I have also received it.
They are supposed to file it. They are supposed to file some supplementary application.
Direction was more that you will appear before the
We have appeared and we have received an explanation.
There is the, it's, I'm there, it says, ACP. Mr. Garudia was perhaps a bit last. This, entry,
Item 23.
they say that they have been cooperating with the investigation. They were asked to go. The final affidavit of this.
I was there in this case. I was present on that day of hearing,
Yes.
but I have not accepted any thing of ACP 9 of 2025.
I just don't know. Your appearance is recorded, you must be there, otherwise I will not record the appearance.
Yes, Council for
And
Opposite Party
in
ACP.
one name, Priya Shrestha was it?
Yes, that she is Priya Shrestha appearing.
She's appearing.
I think my name is not recorded,
In one ordinary,
she
she is also.
and her name is appearing in the list today. I have only taken over 5-6 matters which I have given my consent. I have not given my consent for all matters for ACP.
Maybe that we are waiting on that.
Huh.
Yes, we are maybe, because there are on that day, 2 such orders were passed.
No, yes, next one is I am there. Next one, your Lordship, 24, I am there. I'll inform her from you.
But she has not come to the court, she will be joining online at 2:15 in another case, right? In another case, practice.
No, also you asked me what I did.
We'll ask them to file an affidavit as to what exactly happened.
Item 24, ABA 1079 of 2026.
This Marod I appeared as a leadership. He has cooperated, Marod. He had come to us and had done only one thing which I just wanted to point out. If you are waiting, say we can file an affidavit to the limited extent. He has, Marod, the petitioners have sold 30 decimals of land. When they came to us, there are 30 decimals belonging to 2 separate plots, 1062, 1063. He has been able to give and show the documents for 1062 of 22 decimals. And 8 decimals, no documents, nothing have been given to us. So to that,
Has he vacated?
Huh?
Has he vacated?
Pardon me?
Has he vacated that?
That I did not know. He has handed over possession, I don't know. I forgot to ask. The purchasers are in possession of the property. But they
And
have
they are the sellers,
They
have no documents.
no documents pertaining to 8 decimals of land. There are total 30 decimals sold by a common deed.
So whatever they had, they have reduced. Now the point is whether they are intact or not.
Correct. So if a ladyship says I can just put an interim order maybe if I put it on affidavit, let it be next week, interim order may be continued, then our ladyship may continue.
This time because yesterday also we were called. This is 5 days we have cooperated and in future also we cooperate.
No, cooperation is not sufficient because if there is something incriminating coming and you have no documents with respect to the property which you have sold, right? Then you may not be entitled to anticipatory. Mere cooperation is not sufficient for your entitlement to anticipate, correct?
Yes, yes, that is why I
So
wanted to bring
therefore,
it up.
if you are not producing the documents with respect to the property which you have sold, any date fixed for your appearance?
Yesterday only we called. Again, I talked to them and talked about the
Is there any
consistency.
We had called him last, petitioner last on 23rd July. They came yesterday of their own, but we have not called.
We have receiving solicitors.
This is what my instructions from my officers were. We have not called him yesterday. He had come of his own yesterday, but till date, that 8 decimal documents have not been produced. So just give her next week.
I'll give you 2 weeks time. I'll give you 2 weeks time.
Yes.
Fix one more date.
Okay.
If they have any, they will produce.
Yes.
Right? You get it? Yes. AD number 1079. The council for the parties submit that 1 or 2 more dates may be required for the examination of the
Petitions.
petitioners. At the request, post this case on 13th August.
Yes.
Council for the ACB is directed to file a supplementary affidavit in this case by 12th August.
And you want to
My
continue.
entry order.
Okay, motion.
Item 25, APA 3012 of 2026.
So this case. Offense 406, 420, 409 of PCC and section 346 of private police officer wedding. And section 68 of police. So, based on the charge sheet has been submitted. So, starts at page number. $85. Unacceptable.
You file your counter.
Yes, sir.
Page number
85. My name comes as page number 90.
page number 90.
Serial number 5, Abhijit Lal. I'm concerned with the serial number, sub-serial number 9,
Director
Director of Mrs.
Ramayana
Ramayana Pharma Limited.
Farmer. Yes.
So this we can come to page number 108. Therefore, this material is to treatment. The investigation has revealed that Mrs. Ramayana Pharma Limited, therein because PA was a
You
property.
read from paragraph.
Number 2.
Yes.
FIR number 234 of 2013 dated 15 Act 2013 of Chikunda PS District Dhanbad was registered on the basis of the complaint lodged by Sri Ranjit Kumar Verma, son of Satyadev Prasad Verma, resident of Maitrimo, Kumar Rupi, District Dhanbad, where it is alleged that Mr. Pudar and 14 others FIR named accused persons treated the local people, including the complaint, by collecting money on the pretext of registering the same in the protected schemes of their company named Mrs. Ramayana District Limited. The complaint, Sri Ranjit Kumar Verma and 7 others has been listed across rupees 1.12 crores under different scheme of Mrs. Ramayana District Limited on the promise of good return. The complainant had further alleged that many more persons had also invested with the accused company and cheated the public for around 25 crores. Though no specific details of the investment has been given in this regard, the complaint. The company did not pay the majority amount to the investors, and invested amount was submitted by them between the year from 7 to 31. Investigation has revealed that Ramayana Group collected money from public at large through its 3 following companies: Ramayana Pharma Limited, Ramayana Industries Limited, Mrs. Ramayana Real Estate and Infrastructure Limited. Investigation revealed that Mrs. Ramayana Pharma Limited, because RPL was incorporated on 21/7/2006 and was registered with the registrar of companies, West Bengal, Kolkata, with corporate identity number suppose. And this register office addresses was shown at 3 Krishnanagar Road, North 24 Pargana, Barasat, Kolkata. Rameswar Udar, Sukanta Dev, and Ramendra Mohan Sarkar were the directors of the company since the inception until the period of office. One person, namely Abhijit Nagri, joined the company on 7/5/2012 as director and resigned from the post after about 5 months, that is on 1/10/2012. As per the memorandum of decision of the objects of the company were to carry out business as manufacturer, importer, exporter, as service traders. Dealers procedures refiners, purchasers, manipulate, finish it, pack another service. Investigation.
What is your case?
My case is the amount which is being sold. So you can come to page just
Does
page
not
number
belong to your period.
period है, but with regard to the company in which I was the director, उसमें कोई भी connection नहीं है, एक is not है.
कोई investment नहीं.
Parallel है, उसमें
Correct.
investigation has disclosed that above mentioned companies of Raman Group collected rupees 1,84,59,100 from local people of Chirkunda through its branch at Chirkunda, Dhanbad during 2007-2013 under the 5-man scheme. 5 means the scheme was collections are as follows. 5 schemes has been with the amount. So with regard to the particular amounts, let's we kindly come to page very next page 130.
What is the next
Para
one?
40.
We'll come to the next one first.
Annexure 1 is a complaint. That's all. FIR.
There is one annexure one also. The FIR. Where is that?
This is the
Yes.
CBI
Where is that
register.
annexure one?
Annexure 1 starts with page 51.
Page 51. No. You see, is annex with the charge sheet as annexure one. What is that annexure one?
On this page 112, 122, so you can see
What?
the list of enclosures. List agents of investors, annexure 1. List of documents, annexure 2. List of witnesses, annexure 3. Page 122.
No, this is what I want to know. Where is the list?
So that is only
Because there must be some investment in your company or not. This is what we want to see.
yes, that I'm showing also from the chart.
Okay.
Page 112. The 5 schemes are there. The amount has been shown in respect to the schemes. That's a paragraph 14. Each amount has been discussed. With regard to the first monthly product scheme, 1,12,49,100. Investment, paragraph 14. Investment has revealed that a sum of rupees 1,12,49,100 had been collected under monthly product scheme during 2008-2013 by Messrs. Raman and Sons Limited. I am not concerned with this. Now, let's move on to paragraph 16. The very next amount. These two amounts, 2 and 3 has been added, and that is paragraph 16. Investigation has further revealed that the sum of rupees 59,33,000 had been collected under optional fully convertible debentures scheme and 1 number certificate issued to the investor during 2008-13. Mrs. Raman Industries offered monthly income scheme or MIs resembling the monthly scheme suggested. This is mentioned in come to next one, very next page, 114. Again, it says these all is issued by Mrs. Raman Industries Limited. Now, paragraph 70. The fourth one. 4,67,000. In paragraph 70, investigation has also revealed that the sum of rupees 4,67,000 had been collected under redeemable preferential sale. Mrs. Raman Industries Limited and Mrs. Raman Pharma Limited issued redeemable preferential sales scheme to collect money from the public at large. This scheme was projected among general public as a fixed deposit. Now let's paragraph 15.
Just a moment, your name is coming out of the You issue this redeemable preferential share.
Also, when the amount of the others was also paragraph 18 with regard to the last still number 5. Investigation has revealed that the sum of rupees 8,10,000 had been collected under the secure non-convertible redeemable debentures scheme, which was similar to the optional fully convertible debentures. The face value of these debentures was 1,000. This scheme was projected by the accused persons through their company named Messrs. Ramin Real Estate and Purchase Limited. Person legally come there. Paragraph 23, page 170. These are the bank accounts which is maintained by the companies. Paragraph 23. Investigation has disclosed that the company and its directors had opened different bank accounts in which the money collected from the investors of the Chikunda branch of district Mumbai, Jharkhand has been deposited. The details of the accounts are as follows. First, second, third, and fourth, in which the director's name was given authorized signatory. The third column. My name is not. I was not operating the bank accounts.
You are not operating the bank. This was a director of it.
उसके बाद बता कि वो जो सिग्नेचर्स है जैसे जितना भी कन्वर्टिबल बेचेस के ऊपर में उसमें सिग्नेचर किसका वो मेरा सिग्नेचर क्या है उसके बाद paragraph 24. The investigation has also revealed that the statement of the bank accounts corroborated the fact revealed by the branch officers that the money collected from investors of Chirkunda area were deposited in the bank accounts of the companies maintained at Axis Bank, Barsat, Asansol, CC, Bank Asansol, Barsat, and SBI Barsat. The bank accounts in the name of Raman Industries Limited has been maintained at Axis Bank and ICICI Bank, whereas the account in the name of Raman Pharma Limited were maintained at SBI Barsat. The money deposited in the bank account were misappropriated by the accused director Ramendra Putta, Rameshwar Putta, Sukanta De, and Ramendra Mohan Sarkar. There is no allegation against them. I have misappropriated. Now let's see this page number 119. Paragraph 27. Investigation has revealed that Rameshwar Putta and Ramendra Mohan Sarkar were the directors of all the three accused companies, Ramin Pharma Limited, Mrs. Ramin Industries Limited, and Mrs. Ramin Real Estate and Infrastructure Private Limited. Since inception till the period of commission of the crime, they were also the authorized signatory of the accounts in which the amount collected from the investors of Chirkunda area, as above were deposited. Their signatures in the printed form were found on the certificate issued to the investors in OFCDs, RPS, MIS, and CRD scheme of the Mrs. Ramin Industries, Mrs. Ramin Pharma Limited, and Mrs. Ramin Real Estate and Infrastructure Private Limited. Their signatures were also found in the balance sheet submitted in the ROC Kolkata by the accused company during the relevant period. They used to hold frequent meetings of the investors and agents, and during such meetings, they used to deliver motivational speeches for alluring investments. During meeting with these agents of the investors, they used to project a rosy picture about the future of the companies to ensure the investor related to the investors. Where at the same time, they in criminal conspiracy with the other accused directors misappropriated the critical services. Let's we continue expose. Paragraph 20. Again, the same thing is I joined the company, Mr. Raman Pharma Limited only, and I have remained for 5 months only from 7/5/2012 to 1/10/2012. This is only against numbers. The entire. Let's mechanically come to thereafter. Next 4. By the order of the Calcutta High Court, a one-man committee has been formed by a retired Justice S.K. Tarabdar. And in that case, the process has been initiated for auctioning the company's assets, and the same is being repaid to the investors. In that also, we can see. Then another notice is paid 155 rupees. This is one more.
This is what I'm saying. Let's say the property which is also being sought by the order of the Justice Salazar Committee and by the SEBI. In all their those 3-4 directors, the other directors, they have been taking care of it. They are selling the property. They are doing it. I was concerned with the 5 years. What I'm saying is, in my period, there was nothing has happened. I was not the press secretary. I have not signed any document. Only against me, I was remained that as a 4-5 months. Except this, there is nothing against me. Nothing has come to me. I was not the beneficiary. Nothing has come to my account. I was not even authorized to do any business with the properties.
Before coming to the merits of the case, Lordship, I'm just referring to few dates, Lordship. Lordship, on 30/12/2017, that is in respect of the conduct of the petition. 30/12/2017, Lordship, charge sheet was filed. Thereafter, Lordship, on 2/1/2018, Lordship, the cognizance was taken. Thereafter, Lordship, he filed anticipatory bail petition in the court below, Lordship, that is ABP 616 of 2018. That was rejected, Lordship, on 7/6/2018 itself. Thereafter, Lordship, what has happened is that the CBI tried to secure his presence, Lordship, in the court, Lordship, because other co-accused, Lordship, they had appeared, Lordship, they were in custody, and ultimately what happened, Lordship, that the summon was issued, then BW was issued, and when BW was issued, Lordship, then he gave an undertaking, Lordship, when the Lordship kindly see, Lordship, he gave an undertaking, Lordship, that he will appear in the court below on 27/7/2022. It is signed by him. But in spite of that undertaking, Lordship, it's still we are in 2026, Lordship. Even after 4 years, Lordship, he never appeared in the court below, Lordship. Now, Lordship, after a lapse of almost 8 years, Lordship, from the date of his first rejection, Lordship. Now, again, he has filed the anticipatory bail application, Lordship. So, my humble submission, Lordship, is that considering the conduct of the petitioner, Lordship, since it is defying the authority of law, Lordship, is not entitled to anticipatory bail. And, Lordship, this proposition of law, Lordship, was held by Honorable Supreme Court, Lordship, in the case of Srikant Upadhyay, Lordship, reported in 2024, volume 12, SCC 382, para 20 and 30. 382, page 382, para 20 and 30. So, Honorable Apex Court has held, Lordship, Srikant Upadhyay. Yes. So my humble submission, Lordship, is that from the day one, Lordship, in 2018 itself, he was well aware, Lordship, when he first moved his anticipatory bail application, that he has to appear, Lordship. Now,
He did not cooperate during this.
did not cooperate, Lordship. He has also defied the authority of law. He has not appeared in the court below. And what happened, Lordship, in this case, Lordship, is that so far the other accused persons are concerned, Lordship, the record was split up. The charge was framed, Lordship, on 11/3/2024 against other accused person, Lordship. 11/3/2024, Lordship. Charge was framed against other accused person, Lordship. But this petitioner, Lordship, is still not appearing in the court below, Lordship, and he has prepared this. And so the conduct of the petitioner, Lordship, does not entitle him to grant of anticipatory bail, Lordship. And secondly, Lordship, so far the allegations are concerned, Lordship, it's there in the charge sheet, Lordship, that this petitioner was involved in collecting the money for the company. This Ramal Group, Lordship, had 3 companies, Ramal Pharma, Ramal Industries, and Ramal Real Estate. He was the director of Ramal Pharma, Lordship, and we have stated in our counter, Lordship, that at paragraph 12, Lordship, of the counter, Lordship, that he was involved in collection of the money on behalf of the Ramal Group, Lordship. It's a very big web, Lordship, and whatever my friend may justify, Lordship, that money came, did not come, or whatever, Lordship, but the fact of the matter is, Lordship, that this chit funds scheme which they were running, Lordship, they had no license from the SEBI, no license from RBI, no license from ROC, Lordship. Therefore, whatever the justification my friend may give, Lordship, that will not make their actions legal, Lordship. And it has come in the charge sheet also, Lordship, that they were involved in collection of money, Lordship, by luring poor investors, Lordship. And at paragraph, I'm just placing that particular paragraph, Lordship, of the charge sheet, Lordship. Yes, Lordship, I am referring to page 120, Lordship. 120 of the charge sheet, that Abhijit Nag was the director of the accused company, Ramal Pharma. He joined the company on such and such, and he along with Anjan Das, they used to hold frequent meetings of the investors and agents, and during such meetings they used to deliver motivational speech. During meeting with the agent investors, they used to project a rosy picture of the company and to ensure investors they partnered in fraudulent collection of investments. And the
This is para 120 of this day.
Lordship, that is para 29, Lordship, of the charge sheet. Page 120, Lordship. Page 1. Page 120, paragraph 29. So he was involved in those illegal acts of the company, Lordship, for running that chit fund scheme, Lordship, which they never had license, Lordship, from the relevant statutory authorities, Lordship. So my humble submission, Lordship, that this petitioner does not deserve to be granted anticipatory bail, Lordship, also considering his conduct, Lordship.
So small misunderstanding. With regard to the statement at paragraph 17 that he has granted bail, this petitioner, let's make and come to paragraph 17 of the ceasement. Their counter. They have said the paragraph 17 of their counter.
Will you appeal on 27/7/22?
No. So what I'm saying, that pursuant to the warrant, the accused executed a bail bond under section 51 of CRPC on 16 public 17, 7/2022, and expressly assured that he would appear before the court on 27/7/2022. However, despite such undertaking, he is paid to appear. Now he said he has granted bail. We can come to section 81. I have quoted in my rejoinder also. The moment he submit the CBI submit charge sheet, he becomes part of service. He has nothing to do with it. He cannot even touch the production ma'am anyone. This is for the court only to decide. Lordship, can you come to page paragraph? 81 एक छोटा सा लिख दीजिए. 81
आपका एंटिसिपेटरी बिल इतना पहले रिजेक्ट कर दिया आपका स्कूल है आप इनके नोटिस को रिस्पॉन्ड नहीं करते
नोटिस में सारे रिस्पॉन्ड किया गया है. एक नोटिस में रिस्पॉन्ड किया. सेक्शन 81 में ये कहते हैं कि अगर ये बेलेबल ऑफेंस है और ये इन्वेस्टिगेशन पेंडिंग है, देन ओनली ही कुड गिव ग्राउंड बिल टू अस. अदर ये नॉन बेलेबल है, जो हम लोग केस है, द कोर्ट हैज ओनली पावर.
Lordship, you are assuming for the sake of argument, Lordship, that the IO has no power for granting bail. But he has given an undertaking that he, yes, you said should go anywhere.
You say that
document के खुद का signature नहीं है इसमें.
It is his signature, Lordship, that he will appear.
When it comes to summits that he is appealing his arrest in connection with RC case number 8 within bracket S of 2016 slash CBI slash POWRG dated 29/2016 for alleged offense under section 420 slash 406 IPC, and cognizance has been taken for offense under section 120B wherein section 420 and 409 IPC, and under section 456 of crimes, chits, money circulation, which is banned by the Rules Act 1978, and section 67 and 68 of the Companies Act against the accused persons, including the so when it comes to the petition, summons that the petitioner happens to be the director of the company, namely Mrs. Ramli Pharma Limited, and joined the company on 7/5/2012 as director and resigned from the post after 5 months, that is on 1/10/2012. The council has released the charge sheet and has referred to paragraph at referred to page number 90, and his name appears as accused number 5, showing him as the director of Mrs. Ramli Pharma Limited. He has then referred to paragraph 2 onwards of the charge sheet and has submitted that FIR was instituted on 15/9/2014 in Chekunda Police Station, District Dhanbad, on the basis of complaint against various persons, including Rameshwar Kotar and 14 others named accused, alleging that they had cheated the local people, including the complainant, by collecting money on the pretext of investing the same in attractive schemes of a company, namely Ramen Industries Limited, and huge amount was collected. Further service that, as per the charge sheet, 3 companies are involved, namely Ramen Pharma Limited, Ramen Industries Limited, Ramen Real Estate and Infrastructure Limited. And so far as Ramen Pharma is concerned, it was incorporated on 21/7/2006 and was registered with the Registrar of Companies, and the petitioner was admittedly director of the state company only for a limited period. The legal counsel submits that the investigation also revealed that branches of the company distributed vouchers, pamphlets, leaflets of the company showing basic area of the company, real estate, packaging, drinking water, pharmaceuticals, etc. And the details of various investments in each of the company has also been mentioned. Please refer to paragraph 11. Which shows a total amount of investment of rupees 1,884,59,100. And then he has referred to other paragraphs. He has then referred to paragraph 17. To submit that investigation revealed that a sum of rupees 4,67,000 was collected under redeemable differential share scheme from by Mrs. Ramen Industries Limited and Mrs. Ramen Pharma Limited. Which was to be paid upon mutuality, and has referred to paragraph 18 to submit that a sum of rupees 8,10,000 was collected under secure non-convertible redeemable debenture scheme. The legal counsel submits that none of the legal counsel further submits that the amount which was deposited from the Chekunda branch has been summarized in paragraph number 23, which shows that an amount of rupees 42,56,166 was deposited in the account of Mrs. Ramen Pharma Limited, showing the authorized signatory as well as Rameshwar Kotar and Sukanta Dev, and therefore submits that the petitioner has no role in the entire transaction except that he was a director of the company, namely Mrs. Ramen Pharma Limited for a short time. The legal counsel submits that none of the documents issued to the investors contain the signature of the petitioner.
Paragraph 5 schemes that is not concerned with this company which the petitioner.
The legal counsel submits that schemes which have been mentioned in paragraph 11 of the charge sheet does not concern with the company, namely Mrs. Ramen Pharma Limited. The legal counsel has submitted that there is no material to connect the petitioner with the alleged offence, except that he was the director of the company for a short time. ठीक है? आपको बहस कितना देर सुना? उसको क्यों नहीं जानने दिए? ये बीच में डिक्टेशन के बीच में हम प्लीज डू नॉट, आई जस्ट नॉट नो। आपको इतना इत्मीनान से चाहिए, आपको जो जजमेंट देना था, जो सेक्शन देना था, उसी समय देना चाहिए। The bits of the dictation I do not accept. नहीं, I mean a stream of thought we do not interrupt like this. I did not interrupt. Did I? No. Yes. We have your patience to listen to all of this. The Learned Counsel for the state on that of the ACP has opposed the prayer for bail of CBI, has opposed the prayer for bail and has referred to paragraph 10 of the charge sheet to submit that the investigation reveals that the directors of the accused company used to hold frequent meetings of the investors and agents every such meeting the accused managing director and directors used to deliver motivational speech. During meetings with the agents investors, the managing director and directors of the company, namely Rameshwar Kota, Supanta Dev, Ramin Mohan Sarkar, Partho Das, Abhijit Nag, the petitioner, and Amini Das used to project a rosy picture about the future of the company to ensure that the investors and the agents invest their money in their savings. The Learned Counsel submits that the role of the petitioner in delivering the investment has come during the investigation. He has further submitted that the petitioner, the charge sheet was filed on 30/12/2017. The cognizance was taken on 2/1/2018. The anticipatory date of application of the petition was rejected by the Learned Court in APP number 616 of 2018 by Robert dated 7/6/2018. Thereafter, summons was issued and ultimately bailable warrant was issued. The petitioner has evaded cooperation with investigation and also arrest for 8 years. He has further submitted that the records of the case also reveal that the case of the accused has been split up on 11/3/2024 and trial is going on. The Learned Counsel submits that it's a case of financial fraud. The company of the petitioner never had any license to engage in any kind of collection of money, and therefore, especially the money collected in the name of the company was illegal. He has referred to the judgment passed by the Honorable Supreme Court before during bracket 2024, bracket 12 SCC 382, para 20 and 30. And he submits that neither the conduct of the petitioner calls for grant of anticipatory bail to the petitioner, and there is ample material to collect the petitioner with the alleged offence. And once the petitioner is taken into custody, more materials will transpire during his examination. Very good, sir.
So charge sheet file.
Charge sheet file will be
So he has to honor the summons and orders of the court of law.
Last sentence. After making the Learned Counsel for the parties and considering the fact that admittedly the petitioner was the director of Ramil Pharma Limited, though for a short period, during the period from Seven 5/2012 to 1/10/2012. The fact reveals that the company did not have any license for engaging into any kind of financial transaction with the public. And in Chitpunga circle, a huge amount was deposited in the account standing in the name of the petitioner or in the name of the company in which the petitioner was directed. It further reveals that it has come during investigation that the petitioner was engaged in engaging the agents slash investors to by projecting a rosy picture about the future of the company and to ensure that the investors and the agents and their investment were in safe hands in spite of the fact that the company did not have any license to do the aforesaid act. The role of the petitioner has come during investigation. And really because the petitioner claims that no document as such was filed by the petitioner is of no consequence at this stage. This court also finds that the bail for anticipatory bail of the petitioner was rejected way back on 7/6/2018, and the petitioner has evaded his arrest. The counter-affidavit reveals that the trial court had issued bail warrant against the counter-affidavit also reveals that despite rejection of anticipatory bail, the petitioner did not surrender and continued to evade the judicial process, and a bail warrant against him was issued on 4/12/2019. It further reveals that a bail bond under Section 81 CRPC was furnished by the petitioner under the assurance that he would appear before the court on 22/7/2022. However, the petitioner failed to abide by the undertaking and remained absent. At this stage, the learned counsel for the petitioner has submitted that since the alleged offence were non-billable offence, there was no question of execution of any bond under Section 81 of CRPC. That too after submission of the charge sheet. However, the fact that a bond was executed is not in dispute.
No, we are disputing. We are certainly accepting it. So there is no countersign of the CBI.
We are filing joint.
Yes. Yes, sir.
The learned counsel has submitted that, has referred to paragraph number.
Paragraph number 10, 11, and 12.
एक जगह ना होगा ये सब जगह होगा tell us that this bond was never executed.
Yes, paragraph 10 was released.
This is no occasion. Where have you stated that this bond was never executed?
Yes, paragraph 12. Line number 5. As per the petition, he has not executed any bond by the CBI officers, nor there is any undertaking.
The council has submitted that as per the requirement, the petitioner has not executed any bond as alleged in the complaint. He has also submitted that the assets of the company are being sold by one-man committee, which has been formed by Honorable Kolkata High Court, in which Honorable Justice Palika is heading the committee. This court is of the possibility that the ruling has been directed against the petitioner as is happening from the charge sheet itself, that the petitioner had taken active part in eluding the investors at Chidunga although the company did not have the required license, this court is observing that the petitioner is not entitled to the privilege of description. We will take up the remaining cases in second. And we see that to be found. And we will